You have an interest in remedying the effects of racial discrimination that we identify using this tool. Whether you go too far in your remedy is another issue, right?
Your Honor, I think step zero in all of these cases, it was certainly step zero in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said, we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second
No, it's not. Because that, again, just trust me on this.
They're disabled, is what Ketanji said today in the Supreme Court oral arguments about voting rights. And a very important decision that will come down. Democrats freak that if the court finds that the Voting Rights Act is unconstitutional, at least as it pertains to creating racially gerrymandered voting districts, they might lose 19 seats, and they're not too happy about that. So Ketanji was extra Ketanji today, and Senator Melissa Melendez shared this. She's a state senator over from California, 28th district, retired, says a black Supreme Court justice thinks that black voters need assistance voting because they have the disability of being black. Ketanji, who is also a black woman, pretty sure, although we sometimes get confused about this because that's what Kamala Harris said too. She says they don't have equal access to the voting system because they're disabled, which I think is the same argument that Kamala Harris was making about voter ID.
I'm thinking of the fact that remedial action, absent discriminatory intent, is really not a new idea in the civil rights laws. And my kind of paradigmatic example of this is something like the ADA. Congress passed
the American with Disabilities Act, very similar to black voting districts from Ketanji, okay?
The Americans with Disabilities Act against the backdrop of a world that was generally not accessible to people with disabilities. And so it was discriminatory in effect because these folks were not able to access these buildings. And it didn't matter whether the person who built the building or the person who owned the building intended for them to be exclusionary. That's irrelevant. Congress said the facilities have to be made equally open to people with disabilities if readily possible. I guess I don't understand why that's not what's happening here. The idea in Section 2 is that we are responding to current day manifestations of past and present decisions that disadvantage minorities and make it so that they don't have equal access to the voting system, right? They're disabled. In fact, we use the word disabled in Milligan. We say that's a way in which you see that these processes are not equally open.
What is she saying? Like black people need ramps to get into the polling place or something? I'm not sure. Do they need guardrails or handrails to go cast their ballots? I don't really know exactly what she's saying. I don't think she does either. So it's an interesting comment to analogize a racial group with the ADA, which is about access to buildings in many cases, versus access to the polling locations. So should we create districts for disabled people? Is that her argument? Right now, the argument is we got to carve out these black majority districts for black people. And you say, well, that's interesting because the state is only so big. So if you carve it up for one particular group, then it's in opposition to other groups. Because if you carve it for the black people, you don't carve it up for the Hispanic people or the disabled people, or maybe the L's and the G's and the B's and the T's and the Q's and the I's and the expialidocious people. Maybe they all want a group. Why don't you carve it for them? Or the white Christian men? Never would even think about that. But you get the point. When you start having to carve up your society, it kind of feels like it's not equal protection of the law. Kind of feels like one group is getting more protection, special privileges in order to get certain positions of power. And she says, well, what's the difference with this? We give disabled people, additional rights and privileges so that they don't get discriminated against. So black people are no different than the handicapped. So just deal with it. And I don't really know if that's going to be persuasive in the majority holding, but we'll see what happens. Now, other people who have a little bit more, understanding of constitutional jurisprudence are called Kavanaugh and Amy Coney Barrett. Brett Kavanaugh and Justice Amy Coney Barrett. And they were in here today asking a couple of other questions. Here is what that sounded like when they were having conversations with this woman, Janai Nelson, who wants another special black district because of their disabilities.
Congress included a durational limit in Section 5 of the Voting Rights Act. It created a mechanism for reauthorization. It decidedly did not do that in Section 2.
The issue, as you know, is that this court's cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint. And what exactly do you think the endpoint should be, or how would we know for the intentional use of race to create districts?
Well, Justice Kavanaugh, you raised a very important distinction, and that's between remedies and the statute. So a race-based remedy can and should and usually does have a time limit and a durational limit. Section 2 court-ordered remedies have a time limit. And so that is something that is grounded in our case law. What is not grounded in case law is the idea that an entire statute should somehow dissolve simply because race may be an element of the remedy. So, for example, this case has affirmed Title VII. It has affirmed Section 1982, the Family Medical Leave Act, and also Section 4E of the Voting Rights Act in Katzenbach versus Morgan, and never has it suggested that any of those statutes should dissolve in and of themselves as opposed to the remedy.
I'm sorry to interrupt. I don't think it's the statute. It's the particular application of the statute that entails the intentional, deliberate use of race to sort people into different districts. That particular aspect, I'm asking what you think the time limit on that should be, or there really shouldn't be a time limit. I think you might be saying there shouldn't be a time limit unless Congress chooses one.
I am saying that. I'm saying there should not be a time limit, but I also think it's critical to emphasize that Section 2 does not require a race-based remedy in all circumstances.
Is that because...
Can I ask that? I just wanted to follow up on Justice Kavanaugh's question. What if this is an exercise of Congress's enforcement power? If we're looking at the City of Bernie test and we're saying it has to be congruent and proportional, would that affect your answer to Justice Kavanaugh's question, that if it's going above and beyond what the 15th Amendment requires of its own force, but Congress has actually chosen the Voting Rights Act as a remedy, does that affect the question of whether it can go on indefinitely or not, that at some point it becomes not congruent and proportional?
No, I don't think it does. First, should not apply to Section 2.
Assuming that it
does.
My question is...
Sure. Assuming that it does. As you know, in Bernie, this court held up the Voting Rights Act as the paradigmatic example of congruence and proportionality. The fact that the Voting Rights Act at times may require a race-based remedy does not change the fact that Congress, with its enlarged powers as defined by Ex parte Virginia and the line of cases forward, can address conduct that is beyond what the 15th Amendment addresses. It doesn't need to simply parrot the 15th Amendment. It can address conduct that is even considered constitutional in order to ensure that race discrimination in voting does not go undetected, uncorrected, or undeterred, in the words of the Senate report.
We have another clip here of Ketanji getting into it with Louisiana. So this is the Louisiana Solicitor General who's saying, we don't want any more racially clarified districts in Louisiana. We had to do the last one because you guys made us, but it's racist. So how about we stop doing that? And Ketanji is being extra Ketanji. Don't worry, we're going to wrap it up with Clarence Thomas next. But here is Jackson just unloading on this because she has a strong affinity for her disabled
I don't understand
friends.
why your answer to Justice Kagan's question about is this a compelling state interest is no. The answer is obviously yes.
Okay, so compelling state interest, we talked about that yesterday. When you're going to infringe on a constitutional right, in this case, let's say it's equal protection under the law. All groups are treated the same. Every person, you don't get a special privilege because you happen to be black or Mexican or gay or white or whatever. It's all the same. And in her instance, the question is, if you're going to violate that equal protection, what is the reason for doing that? Is it compelling? Like, it better be pretty damn compelling because it's a constitutional amendment. It's a big deal. So if you're going to infringe on that, what is your reason? Now, their argument is past discrimination is a very compelling reason, and it overrides everything. Because, of course, as we know from their perspective, racism is the worst thing you could possibly be. I mean, you can murder somebody, and that's less bad than being a racist. Just ask college kids about Charlie Kirk and him. He was a racist, so he deserved to die, okay? They're nuts. That's literally like their moral hierarchy is so perverted that they endorse murder if they think that you don't like black people or something like that. It's crazy, which he didn't at all. So anyways, here's the exchange, and she's just going to go on a tear here, but that's what she's talking about. It's very compelling to me
that you have an interest in remedying the effects of racial discrimination that we identify using this tool. Whether you go too
that who identifies exactly
far in your remedy is another issue, right?
Your Honor, I think step zero in all of these cases, it was certainly step zero in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said, we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second
No,
majority.
it's not. Because that, again, just trust me on this.
Trust me on this, bro.
Second electoral or second district is a remedy that one could offer for a problem that we've identified. And the whole Robinson litigation was about identifying the problem. Is this really happening? In many Section 2 cases, the court says, you're wrong, you're fine. There is not an electoral opportunity being denied to you. Go away. In this case, the court said, I see. I'm looking at the factors. I appreciate what you're saying. You've proven that we have this problem. And so the next question is, how do we go about remedying it?
And in their mind, you just carve up voting for certain groups to remedy and rectify whatever they call and whatever they make up to be past discrimination for whatever group that they want to rig the elections for. So Clarence Thomas came out to clean the palate, to cleanse the palate. Here is what he had to say when he was talking to Louisiana from the Supreme Court.
What role did Robinson play in the development of SB 8?
Justice Thomas, Robinson is the only reason SB 8 exists. We fought tooth and nail in the Robinson litigation itself in telling the courts that we did not think the Constitution permitted us to draw a second majority black district. As you know, under protest, we drew SB 8 because the threat was that the federal courts were going to do it if we didn't. I think that's the best way to conceive of why SB 8 exists. We would never pass SB 8 in the first instance without Robinson, Justice Thomas.
What were the findings in Robinson?
The finding by the Middle District in Robinson was that plaintiffs in this case were likely to show a violation of Section 2. And the likely violation, and I'm using very broad terminology because I do not know what the underlying violation is. I can't articulate that for you, Justice Thomas, because I don't think anybody can. But I think the finding in the district court's mind in that case was that the likelihood of a Section 2 violation meant that a majority black district was required, a second one. And I think that was the bottom line. And when our legislature saw that, we understood the marching order, and that's why you see SB 8 as it exists today.
Just briefly, what were the findings that led to that conclusion?
Well, Your Honor, running through the preconditions and the totality of the circumstances, I think the totality of the circumstances did most of the work for the Middle District in Robinson. Senate Factor 1, the official history of past discrimination, Justice Thomas, we can never outrun the bad era of poll taxes, of grandfather clauses, of literacy tests. I think we're always going to lose across the board on that kind of analysis, and that's what the Middle District in Robinson focused on, is how bad was Louisiana in the 1930s, 40s, 50s, 60s, and, add all that together, and at the end you have a vote dilution finding that I don't think is clearly articulable in the way that SFFA requires a finding of discrimination to be specified.
Great argument, yeah. So again, it's the original sin of America. Can never escape it. It's always going to happen in perpetuity. So we made these laws to say, well, we're going to go and remediate some of this past discrimination because it was wrong. And we've done that. But now we need to do it again and again and again. And Gavin Newsom needs to pass or create some reparations committee in California, which was never a slave state. Nobody there ever owned slaves. People who are living there were never slaves. And now we have a whole reparations system set up. So they, cater to certain demographics to fulfill their electoral obligations so that they keep getting elected. And of course, it's unconstitutional and illegal. And now the Supreme Court is about to weigh in. Hopefully we get a nice big fat decision, 6-3 or better, saying unconstitutional, racially crafted districts are violative of the Constitution. There is not equal protection and it needs to go. We'll see what the Supreme Court says on this one when the ruling comes down. Thank you for subscribing and joining as we do.